Good evening, everyone, and welcome to our new webinar episode on international arbitration with Alternative Dispute Resolution Clinic. Today, we will be covering an important topic for Armenia, environmental protection and human rights under Armenian bilateral investment treaties. Before we begin the webinar, I want to inform that the event is being recorded, and if you don't want your name to appear in the Q&A section or elsewhere, please refrain from using those. Otherwise, please feel free to direct your questions to a Q&A function at the bottom right corner of the screen. We will start our webinar with Julian Scheu's presentation on human rights and international investment law, where he will address the commonalities, the differences, and the interaction between the two. Dr. Scheu is a junior professor of public law, international law, and international investment law at the University of Cologne and general manager of the International Investment Law Center, Cologne. He studied law at the University of Cologne and Paris I with a specialization in international economic law and is qualified to practice law in Germany. Prior to joining the University of Cologne, he worked as a legal assistant at the German Arbitration Institute, DIS, in the field of German and international arbitration for a number of years. The webinar will be continued by Camilla Gambarini presentation, who will be focusing on relationship between environmental and investment law. Some of you may already know her from our September conference on investment disputes. I'm sure she will need no introduction to those of you who are current Young IICC members as well. Camilla is a senior associate at Wilters in London. She is qualified to practice in Italy, England, and Wales, and specializes in international investment, treaty, and commercial arbitration under ICC, ICSID, UNCITRAL, and other arbitration rules. Her public international law experience includes advising states on the protection of investments under international investment treaties, boundary disputes, natural resources, and human rights. She holds a master's degree from Columbia Law School and Graduate Institute, and as I mentioned, she has served as a Young IICC co-chair for past 2 years. At the end of our webinar, we will have Levon Volenduchin presenting on Armenian bilateral investment treaties in light of the two prior presentations. Some of our students might recognize him, since we had already had a chance to participate in his lecture at AUA on the topic of consent in investment arbitration. Levon is an international dispute resolution associate at Eversham Sutherland. He has successfully counseled clients through all stages of dispute resolution process, from pleadings to appeal to enforcement, and has appeared in both federal and state courts and before arbitration tribunals. Prior to joining his current firm, Levon worked for an international dispute resolution firm where he counseled clients for sovereign states to private companies in mining, agricultural, and transportation sectors. He holds an LLM degree from a London School of Economics and a political science and a JD degree from Columbia Law School. Without any further delay, we will start our webinar event, and I will give the screen to Julian to start his presentation. Thank you very much. Julian, just a second. You can start, share your screen, Julian, and start your presentation. Thank you very much.
So, can you hear me? Thank you, Aram, for this very kind introduction, and many thanks to the ADR Clinic for organizing an event on such an interesting topic. It is a great pleasure to be with you today, and I will be setting the stage for our discussion, and I will address the legal framework which governs the interaction between international investment law and human rights. And I hope that this works. Okay. So, can you see my screen? Does it? I hope we...
Yes, we can see your screen and your presentation, Julian. You can
okay, perfect. So let me start with addressing the fact that we think about the interaction between two subfields of international law. international human rights law and investment law. What are the commonalities? What are the differences? And how does their interaction take place in the context of investment treaty arbitration? So first of all, maybe we spend a little moment to ask ourselves, what are these fields of law all about? And I give you a very brief working definition, which is vague, but maybe captures the most important aspect. You can say that human rights law is about protecting the dignity, the physical and mental well-being, and social economic development of all human beings. On the other hand, international investment law is about protecting the value of foreign investments subject to legal, economic, and nationality requirements. So you see, I underlined the word protecting, and it is clear that this is to a certain extent a commonality, because both legal regimes are about protecting legal rights held by private individuals. However, the differences are striking as well. The nature of the rights are different, and the scope of the rights are different. Whereas human rights law addresses all human beings, investment law is only available to some foreign investment projects, those who fulfill the legal, economic, and nationality requirements set out in a specific treaty. So with these first introductory remarks in mind, let us think about the process of investment treaty arbitration. And I'm sure most of you know how it works, but I will very briefly recall that it is an international treaty, more often signed bilaterally between two states, a home and a host state. The treaty provides investment protection standards such as fair and equitable treatment or full protection and security to foreign investors, and it includes a right to bring arbitration claims for damages in case the host state might have violated these investment protection standards. This is, in a nutshell, basically what investment treaty arbitration looks like. So when an arbitral tribunal has to apply this treaty, it is often confronted with vague terms like fair and equitable treatment. So it must engage in a process of treaty interpretation. It will therefore rely on the general principles of treaty interpretation enshrined in the Vienna Convention on the Law of the Treaties, and its general rule in Article 31, which states that a treaty shall be interpreted in accordance with its ordinary meaning, but also in light of its object and purpose. And starting from here, I want to briefly illustrate you what is, in my opinion, important to keep in mind when it comes to interpreting investment treaties. What is their object and purpose? So the object of an investment treaty is the protection of foreign investments. As we've seen, that is what it's all about. If you look at an investment treaty, what is in there? There are investment protection standards and procedural rules how to implement these standards or to enforce them. What is this investment protection about? Well, the aim is to attract foreign capital. The attraction of foreign capital is an important but only an intermediate goal, because the mere existence of foreign capital in a host state is not really helpful. It is just meant to stimulate the local economy in order to achieve the veritable purpose of the treaty, which is the promotion of sustainable economic and social development. This is the policy perspective we should keep in mind when it comes to interpreting investment treaties. In this sense, an investment treaty is a policy instrument which is based on this rationale. And that this rationale works, two important requirements must be taken into account. The first one is that investment protection needs to be effective. Otherwise, foreign investors won't rely on investment protection standards and won't take them into account when they make their investment decisions. So attracting foreign capital only works if investment protection is effective. On the other hand, let's say we have investment protection which is effective and we have attracted foreign capital. The question arises how we come from the intermediate goal to the veritable purpose. Well, here, investment law needs to take account of the necessary policy space every host state and every political government needs to have in order to transform the economic stimulus created by foreign capital into sustainable and economic development. These are, I think, an important conceptual background when it comes to the interpretation of international investment treaties. How does this affect the relationship between investment law and human rights? It is a very complex situation and interaction, and I will not have the time to go into every detail, but I very briefly can summarize it in three different constellations, which can be divided. The first one is the reinforcement of investment protection by human rights. It is an often overlooked aspect of the discussion because it takes into account the fact that foreign investors are themselves often protected by human rights law. Think about the human right to property, the right to a fair trial and due process, or the right to non-discrimination. On the other hand of the spectrum, we have the abuse of investment law at the expense of human rights. This takes into account the sad cases where foreign investors and their conduct lead to human rights violations in the host state. Think about the violation of labor rights, such as the use of child labor, violent repression of peaceful demonstrations, forced relocations, or any other abuse of private forces. If the investor's claim is then instrumentalized to prevent the host state from protecting the human rights involved, this would amount to an abuse of investment law at the expense of human rights. In the middle of these two constellations is the conflict between human rights and investment law, and I think this is the one which is maybe the most difficult one to identify and to cope with, and at the same time the most relevant in practice. So in the interest of time, I will focus here briefly on the conflict between the two legal fields. What I mean by that is a situation in which we have a human rights sensitive or problematic situation in the host state. Think about civil unrest, think about an economic crisis, natural disaster, COVID-19, you name it, any kind of situation where the obligation to protect is triggered due to the human rights obligations ratified by the host state. So the host state enacts measures to safeguard human rights. And unfortunately, these measures sometimes tend to adversely affect foreign investments, and we have a violation of that same measure, which is meant to protect human rights, which violates the investment protection standard. So here we have a potential conflict between the two. What does conflict in a legal term, in a legal sense, mean? We have to take into account that there is no absolute protection, neither of foreign investments under international treaties, nor there's absolute priority of treaty-based human rights. You may have you may find one position more important than the other, but in legal terms, both are derived from international treaties and therefore are in a legal sense on the same level, and therefore it cannot be resolved by a hierarchy of norms. This is why we have a conflict in a legal sense. And you may notice that I wrote treaty-based human rights, because we have not only treaty-based human rights, but especially preemptory norms of international law, the jus cogens. These are these have priority, but in many cases it is the treaty-based human rights which are relevant in investment disputes. So how does a tribunal react when it is faced with this kind of conflict? It must, to a certain extent, engage in some kind of balancing exercise. It must take both positions into account and bring them into a harmonious relationship. Because we have seen legally there is a conflict, and we cannot resolve the conflict by a simple yes or no rule. There's no absolute priority. And this is not surprising, given that the whole concept of investment protection is about effective investment protection on the one hand, and taking into consideration the policy space on the other. And human rights norms ratified by the host state are nothing else than part of the policy space which also governs the investment environment. So bringing this to a more concrete example, how could such a balancing exercise by an arbitral tribunal look like? For example, we have the question, did the host state provide for full protection and security? Let's say we have an investment which is facing with protests and is blocked by these protests, and the investor claims that the state did not provide full protection and security. Here, the tribunal will first look into the term full protection and security, start interpreting it, and at some point come to the conclusion that a balancing exercise is needed. Here, a very useful tool is the proportionality analysis, which stems from administrative law, but which is a general principle of law, and it can be found in many legal systems, and it has also been applied by investment tribunals. So a proportionality analysis by the books looks like the following. The tribunal asks whether the disputed host state measure served a legitimate purpose and whether it was suitable to fulfill this purpose. Since it is not the mandate of the tribunal to second guess the political decisions of the host state, here deference must be granted, so a certain margin of appreciation, especially when it comes to evaluating whether something is legitimate or whether something is suitable. The third level is the necessity test, so the least restrictive measure test. And once this hurdle is also passed, the tribunal enters into a proportionality analysis, asks whether the measure or the host state conduct was reasonable in a stricter sense. And here, the effect on conflicting human rights might be an important aspect. So in our example, for example, the freedom of assembly might come into play here, and especially when it is enshrined in international human rights conventions the host state ratified at the time where the investment was made. So here, the the tribunal will have to assess all these factors, and that tribunals are in principle capable of doing such an exercise is, for example, illustrated by in which the tribunal concluded that there is no sufficient evidence supporting the allegations that the Mexican authorities have not reacted reasonably in accordance with the parameters inherent in a democratic state. So, to direct actions movement conducted by those who were against the landfill. So the case was about the construction of a landfill, and there were massive protests. So the tribunal looked at whether the host state reaction was reasonable, and its understanding of reasonableness was inspired by the parameters inherent in a democratic state. And the term a democratic state might be or is, of course, closely related to fundamental rights and democratic rights, such as the freedom of assembly. So here, the tribunal could have, of course, go far more detail and have, in methodological terms, way more sophisticated considerations, but only in this short paragraph, I think it captures the spirit of the proportionality analysis. So to sum up, investment protection is a policy tool which has a certain policy rationale behind it. And the aim is to promote economic and social development. And that this works, we have to keep in mind that investment protection must remain effective. Otherwise, it won't work. But on the other hand, in order to make the best out of the attracted foreign capital, we have to respect the policy space. So tribunals, when they engage in an interpretive process, need to take these policy considerations into account. And one example are the human rights norms ratified by the host or home state. And we have here indeed some kind of a tension between the two, but it is the task of the tribunal to reunite both by a balancing exercise. And a very good method to do so in a structured way is the proportionality analysis from administrative law perspective. So with this very quick walkthrough, I thank you for your attention.
Thank you, Julian. It was amazing. Now we will continue with Camilla's presentation. We'll invite her to the screen now. Camilla, I will share you.
Perfect. Thank you very much, Aaron. Okay, great. Hi, everyone. Again, thanks very much, Aaron, and to the American University in Armenia for the invitation. And indeed, a year ago, we were in Yerevan to discuss another interesting topic on investments disputes in Armenia. So thanks again to invite me today to continue the discussion. So as Aram was saying, the goal of my presentation is to discuss the relationship between international environmental law and investment law. And I have decided to, in a way, follow what Julian has just said, but in a way focusing more on environmental law as such within the international law, and then giving you a broad overview of what are the type of disputes that exist when there is a tension between the protection of the environment and states' obligations under international environmental conventions and foreign investors' interest as protected by bilateral investment treaties. So Aram, perhaps we can show the second slide, which is the one with the contents. Thank you very much. So as you can see, we will then discuss briefly, given the time constraints, 2 case studies, which I think can be very interesting for you all, given the current dispute involving Armenia. The first one is Pakrim versus El Salvador. It was a successful case for the host state. And the second dispute is David Avin against the Republic of Costa Rica. Another interesting case because, again, the tribunal decided it in favor of the host state. And finally, I will draw some conclusions which can be interesting and useful to see the perspective of a host state when it is sued by a foreign investor in the context of an investment treaty dispute having an environmental law component. Okay, so we can move to the next slide. Thank you, Aram. Number 3. Okay, so let's start giving a brief overview of the relationship between international environmental law and investment law. I have to say that Julian has given an excellent overview of the relationship between human rights and investment law, and I shall say that you can translate in a way what Julian has said to the context of environmental law. There is definitely a tension between these 2 areas of international law. But I think it's interesting for you to know that international environmental law is actually a sort of a new area of international law. Before the 70s, there were not many international conventions or disputes that dealt with the protection of the environment. Actually, there was a sort of a piecemeal approach related to the protection of the environment, and in particular, host states decided to protect the environment in a way to regulate the exploitation of certain natural resources, in particular living natural resources such as sealing or whales, or the management of watercourses. The major turning point in the context of environmental law is 1972. You may have heard of this. 1972 is the year of the Stockholm Conference on Human Environment. It's one of the first big conferences organized by the United Nations and stems from a series of events that unfortunately happened around the world, which dramatically impact the environment. And so we are in the years of the environmental movement where there is a sort of awareness that states should protect the environment, even sacrificing economic development. And so in this year, after the 70s, we see that states start to write and sign up to certain conventions precisely aimed at tackling specific environmental law issues. CITES conventions was signed in 1973, which is the convention which protects endangered species, and we have a series of many other conventions dealing with the protection, for example, of pollution, air pollution, and hazardous waste, for example. Another major moment in the history and evolution of international environmental law is 1992. Some of you, particularly the students, maybe were not born then, but I think you should all be aware of the existence of this very important conference organized again under the aegis of the United Nations, which was called the Earth Summit. In 1992, all states understand that actually they should commit to the protection of the environment as they have been doing in the past 20 years. But they see that the protection of the environment should go hand in hand with the economic development of states. And this it's within the framework of the Rio conference that the concept of sustainable development comes into place. And so from 1992 until today, we've seen many other treaties that states start to sign up. Among others, we have the United Climate Change Convention, the Biodiversity Convention, and so on. So the protection of the environment really becomes part of the agenda of many states, not only developed countries, but developing countries, which on the one hand want to protect the environment and the interests of future generations, but at the same time wants to develop economically. So here we are in the area of evolution of international environmental law. But as we all know, and as we have heard before with Julian, at the same time, investment law develops. So we have a series of international investment treaties that starts to be signed. And actually, I would say from the late 80s, we have a huge number of international investment treaties that states decided to sign precisely to promote and protect foreign investment. And it is interesting to see that from the mid-90s, states start, not so often, but I would say in a way, starts to introduce some provisions in international investment treaties aimed at protecting the environment. I will not develop this further because Levon will discuss this angle of investment treaties with a specific focus on Armenia. But in general, I would say that states start to introduce this concept of the protection of the environment within investment treaties, either through some specific exclusions, tackling, for example, natural resources, or by the introduction of so-called self-judging clauses. And so as the number of international investment treaties develops and environmental conventions develop at the same time, we see from the 90s, but I would say in particular after the 2000s, the beginning of some clashes and conflicts between environmental law and investment law. And so we effectively see how environmental law breaks into investment treaty, in the investment treaty world. As you can see on my slide, I tried to summarize the situation, but it's, again, for me, very interesting to see that before the 90s, we had just one case dealing with environmental law matters. It related to the alleged indirect expropriation in the context of regulation to protect a forest. In the 90s, we have just 3 cases, and after the 2000s, we have plenty of cases dealing with the tension of the protection of the environment, natural resources, and foreign investors' rights. So we can move to the next slide. Thank you, Aram. So how we can classify the disputes between a host state and a foreign investor in the context of environmental law? Well, obviously, every case is different, and it's a world on its own. But I think that there are more or less 4 types of investment treaty disputes having an environmental law component. And I've tried to identify them and summarize them in these slides, taking into account, on the one hand, let's say, the point of view of the foreign investor, and on the other hand, the point of view of the host state. So looking at the foreign investor, namely the claimant, I think that the most usual type of dispute that we can have is the situation where the investor makes an investment in the host state, and then at some point the state decides to improve its environmental regulation, potentially resulting in a breach of the investor's rights under the relevant investment treaty. This is something not completely extraordinary, because at the end of the day, all the investment treaty disputes are about this, states' right to regulate vis-a-vis investors' rights under the bilateral investment treaty. Obviously, in the context of environmental matters, there are strong sovereign concerns which form a part of the host state's usual defenses. At the same time, from the point of view of a foreign investor, we have another type or class of disputes, which is not really common, but actually it existed, and I specifically refer to a case against Costa Rica. And it's the situation where, a case against Barbados. And it's the situation where an investor makes an investment in a host state, relying on the fact that the state will take certain actions and measures in order to protect the environment. And indeed, the investment heavily depends on the host state implementation of an environmental law. So when the state doesn't do that, the investor may lose the value of the investment. And as I said, this is very much based on a specific case against Barbados. There are other types of investment treaty disputes with an environmental law component, and I'm now looking at the right side of my table, and I would like to discuss the point of view of the host state. So there might be an investment dispute where the investor has made an investment not complying with local laws. So this aspect is particularly important because obviously if the investor has made an investment breaching domestic law, the investment is not a protected investment under the bilateral investment treaty. And this is a very important aspect that a host state should always consider when it is involved in an investment treaty dispute, because it's actually one of the main objections that it can raise. It's also connected to the concept of illegality of the investment, and obviously this really much depends on whether the investment treaty contains an obligation on the investor to make an investment legal, and so constituting the investment in compliance with domestic law. And finally, very, very interestingly, we've now seen in the past few years a number of investment treaty disputes where host states are sued even in relation to disputes not necessarily connected to the environment, but decide to bring a counterclaim against the investor based on the investor alleged breaches of environmental law. I would say that the same applies to human rights, and this is the case of Orbeser versus Argentina. It's not yet super common, but as I said, we have a few cases, and we will discuss one of them shortly. This particular set of disputes triggers specific questions of jurisdiction and applicable law, but again, it's another important consideration for a host state. So now, having given you a broad overview, I thought of focusing on two disputes actually. There are more than 20 disputes related to environmental law matters, but I thought of discussing very, very briefly two disputes that, as I said, are favorable for the host state, and so in a way fall under the types of dispute that you can see on the right side of this slide. So the first case, and we can move to the next slide, please, is Pakrim versus the Republic of El Salvador. I've tried to summarize this case as much as I could, but just to give you an overview, this is a case involving a mining company, Pakrim, which invested in El Salvador, and it was conducting a series of exploratory and pre-mining activities in different concessions area, and in particular in this area called El Dorado, which was very key for El Salvador because it was an underdeveloped area of the country, but El Salvador was trying to attract foreign investors in order to develop its mining industry. So obviously, Pakrim relied on the sort of concept of legitimate expectations when it started the proceedings against El Salvador. Why we have this dispute? Because at some point El Salvador refused to issue the permits and licenses to Pakrim to exploit the gold reserve that Pakrim discovered in the El Dorado concession area. So obviously Pakrim was not that happy and brought proceedings against El Salvador. Now, this case is interesting because the investor brought the case both under the CAFTA, which is a free trade agreement applicable to the to the United States and Central America, and under the hot state investment law. And I think that obviously it's an interesting case, as I said, because the host state was successful, but you have to bear in mind that ultimately the tribunal decided the case not on the basis of the breaches of the CAFTA, the investment treaty, but of domestic law. So it's of interest, but I would say take it with a pinch of salt. The tribunal found that it didn't have jurisdiction to hear the case under the CAFTA, so it went on to decide the case under El Salvador investment law, which contained an exit arbitration clause. And the central question for the tribunal was indeed whether Pakrim was entitled to obtain the concession. And it was really a matter of domestic law. The question was whether Pakrim, which was not the immediate owner of the land, could obtain the license, or the actual owner of the land had to obtain the license in the first instance and pass it on to Pakrim. So that was really the sort of question, which, as you can appreciate, is not very much an issue of public international law or investment treaty law. But the tribunal conducted a very thorough analysis of domestic law, which was the applicable law in this case. And it found that actually Pakrim had never complied with the requirements for its exploitation concession, because indeed the actual owner had to obtain the permit. And therefore, it dismissed the case and found, therefore, that El Salvador did not commit any breach in deciding not to issue the permit to Pakrim. So interesting case, and I think also interesting because even if the case, as I said, was decided under domestic law, I'm wondering what the findings of the tribunal would have been under a regular investment treaty dispute. If the tribunal found that actually Pakrim did not comply with the requirements under domestic law, perhaps the host state could raise indeed an objection as to the jurisdiction of the tribunal, in particular with regards to the legality of the investment made by the claimant. The other case that I wanted to discuss with you, and it is the next slide, please, is Avon versus Costa Rica. And I think it's a fascinating case because it deals with counterclaims raised by Costa Rica against the claimant. So this case relates to Avon and other individual claimants' acquisition of some parcels of land to build a tourist site. As we know, in Costa Rica, there are a lot of protected areas, and indeed, Costa Rica is often a respondent party in investment treaty disputes, precisely in relation to investment in the field of resorts, precisely because they are built in areas which are environmentally protected. So the same happened here. And so Avon and the other claimants obtained an optional agreement to purchase the properties, which was contingent on them obtaining the permits to develop the land. Costa Rica issues the permit in 2008 and confirmed that there was no issue, and so the construction could proceed. But then the government decided to revoke the permit on the basis that that tourist site could harm the wetlands and the forest. So I would say it's probably even one of the sort of typical investment treaty cases involving environmental law matters, because precisely because the host state, the state decides to tighten its environmental law regulations, then it might breach the foreign investors' rights. So obviously, the claimants bring all the types of breaches that you can imagine under the BIT, in particular breach of the minimum standard of treatment, full protection and security, and expropriation. But what is interesting is that Costa Rica raised an environmental counterclaim against Avon, and indeed the tribunal accepted the counterclaim. I would say because the applicable treaty provided for a provision that included the state's rights to protect the environment. So there was a strict and a sufficient nexus for the tribunal to actually decide the counterclaim issue. Unfortunately, though, the tribunal didn't go ahead in disposing on the counterclaim because Costa Rica filed the counterclaim too late. Costa Rica, under the UNCITRAL rules, which were the applicable rules to this treaty, had to file the counterclaim with the statement of defense, and it fails to do so. It did it later on in the proceedings. And so just because of a procedural issue, all the counterclaim strategy failed. So without further ado, because we don't have a lot of time and we would need an entire semester to discuss all these cases, let's move to the conclusion. And we can move to the next slide, please. Thank you, Aram. Obviously, as you can see, there's an increasing number of disputes commenced by investors against sovereign states in relation to environmental matters. This is due definitely for two reasons. On the one hand, host states rightly decided to protect the environment and their natural resources. And second, at the same time, foreign investors have known about the existence of ISDS, and this is in line with the increasing number of investment disputes that every year we have against the increasing number of investment treaty disputes against host states. What can a state do when it is involved or is sued by a foreign investor? Well, obviously, it very much depends on the facts of the case. So I'm not giving a legal advice, but I just want to give an overview on the basis of what I have discussed and the cases that we have seen. First of all, you have to look at whether there is a precise exclusion in an investment treaty, meaning a provision which says that certain standards of protection would not apply in the case of measures aimed at protecting the environment. And believe it or not, sometimes you can find those clauses, so always check that. Then, obviously, if you are a respondent, you want to knock out the case at the jurisdiction because it's quicker, it's better, you save money. So always look at whether the investor has made and established the investment in compliance with local laws. And when it is a matter of environmental law disputes, well, check if there was an APA or it was done in compliance with domestic and environmental standards. I shall say that, as I noted before, some bilateral investment treaties specifically provide for this obligation to comply with local laws, but there's a line of case law which actually says that there is an implied obligation of having a legal investment. So again, it's something that you can consider when you are putting together your case strategy. And finally, if you can knock out the case at jurisdiction, well, then you have to fight on the basis of your defenses. So definitely police powers, it's a strong defense. Probably tribunal will not accept it entirely. There is this concept of freedom of regulation against investors' rights, but obviously if the measure that is taken is legitimate, made in good faith, it cannot be considered, let's say, an expropriatory measure. So work around the concept of police powers. Second, and this is very much in line with what Julian was saying before, tribunals would balance and take in a balanced approach to see whether actually the measure of the state was proportionate. So you will have to prove that the environmental law measure was made in good faith, was proportionate, and had a legitimate purpose. There is then necessity, which is actually a concept that we find under the International Law Commission's draft article on the responsibility of states, which is Article 25. I haven't seen it in environmental cases, actually. I mean, the first cases that I can think of are the cases of Argentina related to the financial crisis. Bear in mind that necessity is not usually your winning argument, because the test to prove it's very, very high. So you go about it, but with a huge question mark. And finally, think about counterclaims. Usually you can have your counterclaims and so bring disputes against the investor in domestic courts, so you can have parallel proceedings, but maybe you can elevate these domestic claims to an international level to put more pressure on the claimant. So again, there are a lot of options, and very much depends on the facts of the case. But in conclusion, as I said, there is an increasing number of cases dealing with environmental law matters and investment treaties. So definitely it's an area for everyone to watch and continue study, because it's really fascinating. I think my time is over, so I would like to thank everyone for listening to me. Thanks for your patience.
Thank you very much, Camilla, for a very interesting presentation and for analyzing the cases. Those were really useful for understanding the general scope. So now we can give the screen to Levon, who will be covering the Armenian BITs in light of prior two presentations. Levon, you can start sharing your screen.
Let me also unmute myself. Can you hear me now?
Yes, we can hear you clearly.
Okay, great. Let's get started.
Levon, your slides are cut in half. I guess it is because of zooming your video.
Let me see. My slides. So let's. How is this? Is this better?
Yes, I can see your slides. We can start.
Okay. Perfect. No censorship this time. So I'm picking up on the two really informative, really helpful presentations of Julian and Camilla, and sort of revisiting the same topics with a focus on Armenia's investment treaties, but also shifting the perspective from specific legal issues in the context of specific disputes to sort of trying to define a policy landscape that arises out of Armenia's network of investment treaties. So when I speak about Armenia's network of investment treaties, we are referring to over 40 treaties in total, mostly bilateral, so between Armenia and one other state, but also some multilateral treaties where more than two countries come together and reach an agreement about reciprocal protection of foreign investment. Additionally, it's not just a breadth of jurisdictions involved, it's also a temporal breadth, with the oldest treaty concluded by Armenia with I believe it's with America from 1992 up until very recent treaties in 2018 and 2019. So you could say the history of Armenia's negotiation and conclusion of investment treaties is not much shorter than the history of the modern republic itself. The counterparties for Armenia's investment treaties range from states in the West, Canada, the US, Europe, to states in East Asia, to states in the Middle East. Between those, that represents sort of the bulk of the treaties concluded. However, because the time frame spans about 26 years effectively, and for the reasons touched on earlier by Camilla, you have sort of an evolving understanding of how to incorporate and make reference to environmental norms in order to incorporate them into the investment law framework. So, for example, many of Armenia's earlier BITs make little to no express mention of the environment at all. And this is fairly consistent with sort of the practice of investment treaty negotiation and drafting of the early 1990s. This is by context, at that period in time, as Camilla mentioned, there had not been many environmental related investment disputes, and sort of their subsequent rise in later years helped inform how states provided for and modified sort of their drafting of treaties to accommodate that. And Armenia's experience is consistent with that phenomenon. So let's look at a few different examples of how an investment treaty might make reference to or accommodate environmental norms or human rights law norms. We'd heard earlier today reference to sort of exception clauses, and typically these are exception clauses that make reference to specific public interests, whether that's health, environment, human rights, labor. The specific priorities and the breadth of them varies from state, and sort of a recent tendency has been to make them broader. But we need to be careful when discussing whether or not they are actually turning on an element of necessity or not, because simply including the word necessary sort of conceals the full picture. Here, I'm drawing on two clauses from the same treaty, both of which contain the word necessary, but in practice, they are applied quite differently. So in Article 16.1a of the Japan-Armenia BIT, the emphasis is on sort of protecting human, animal, or plant life or health, and the treaty provides that nothing in this agreement shall be construed so as to prevent the former contracting party from adopting or enforcing measures necessary to protect those interests. Whereas in the latter case, the scope is much narrower, it's just essential security interests, but nothing in the agreement prevents a contracting party from adopting or enforcing measures that it considers necessary. The latter, the incorporation of sort of the contracting party's person or own consideration of necessity, has been interpreted to turn what was originally a necessity clause into a self-judging clause. In the latter context, tribunals have little to no, or at least much less leeway to review whether the measure was in fact actually necessary. When you think about the word necessary, it is different in meaning from sufficient. Necessary implies that not only does it achieve the goal, it also is the least restrictive means of achieving that goal. And as Camilla mentioned, in practice, it's this latter aspect that makes it difficult as a defense in investment disputes. Relatedly to public interest exceptions, you also have natural resource exception clauses. They are similar in wording and often focus on either limiting the scope of substantive protections, so the scope of actual protections offered under the BIT to that specific investment, or limiting the investment treaty's application as a whole to specific sectors. So drawing on an example from the US Armenia BIT, under Article 2, the BIT allowed each state to sort of make a list of reservations to limit the application of the national treatment standard, which is the standard that says that a foreign investor should not be treated any less favorably than a domestic investor, to a list of enumerated sectors. In practice, states often list here strategically important sectors for self-sufficiency and defense. So often it's telecommunications, sometimes it's agriculture. But in this case, both Armenia and the US made reservations on sort of public domain, and Armenia also on the extraction of natural resources. In effect, it says that although if you are active in Armenia's natural resource extraction sector, you are benefiting from the investment protections offered under the US Armenia BIT, but we remove from that sort of handful of protections, or that bundle of rights, the right to national treatment. So the fact that a foreign investor was treated worse or in a discriminatory manner as compared to a domestic operator in the same industry is no longer the basis of a potential claim under the US Armenia BIT. And finally, the third type of clause, and I think this was also mentioned earlier today, but I'll focus on sort of how it looks in practice, is looking at legality of the investment clause. And I'm focusing here on actual clauses. I think we'd heard earlier today about sort of other tribunals having implied a legality requirement out of the fact that it has to be a good faith investment or just an investment. Here, just as one example, I pulled the clause from the Canada-Armenia BIT, which puts that legality requirement into the very definition of an investment under the treaty. So looking at the bold language specifically, it makes reference to the latter's laws. So the latter here being the territory of the other contracting party where the investment is made. So in this case, it would be the host state. So investment is defined by reference to legality under the host state's laws. Thus, an investment that does not meet that threshold definition is not considered an investment under that treaty and cannot avail itself of the protections of that treaty. In this regard, I also want to note that, and I provided here the example of Vanessa Ventures, the decision there, but many other tribunals have also held that the legality requirement refers to sort of the establishment of the investment and legality of how that investment was created, and not necessarily compliance with every single law thereafter. Because thereafter, it's no longer a jurisdictional question, because jurisdiction with reference to the investment answers the question of whether or not an investment exists, a protected investment exists. So the classical example for legality is, has often been sort of a corruptly procured investment, but because the specific field of law involved is not limited to sort of anti-corruption or anti-money laundering measures, you can equally have environmental or human rights norms codified into domestic law as the basis for a jurisdiction challenge under the legality requirement. So in the case of a mining dispute, you might, an argument may be made that one or more of the necessary obligations in order to obtain a mining title was not complied with. So whether that's the conduct of exploration, a performance of a valid environmental impact assessment, or any other requirement under the relevant law. Changing pace now to stepping back, one step back from focusing on specific treaty clauses to how Armenia can sort of take its diversity of existing bits and sort of try to normalize or standardize the levels of protection offered across its treaties and improve predictability of disputes. I wanted to focus on a couple of different strategies that states can pursue in this regard. The first being a strategy that would apply before a bit is concluded, and that is the practice of using a model bit. So an increasing number of states are drafting their own sort of model bits that are draft agreements, in essence, that would form the basis of negotiations with the counterparty towards arriving at a treaty that both sides are comfortable executing and ratifying. The advantage thereof is that it allows the drafting state to present sort of what are the elements that it insists on including, or sort of starts the negotiations on the basis of certain assumptions. And those assumptions would be consistent from treaty to treaty to treaty. The disadvantage or the challenge in practicing model bits is that often the effectiveness of them is a function of the bargaining power of the drafter of the model bit. So a smaller state negotiating with a larger state, or a state that frequently practices investment agreement negotiation, will have less leeway to sort of to win accommodations for definitions or clauses that the other side is not already comfortable with. Next, once a treaty has been concluded, there is the practice of issuing notes of interpretation. Notes of interpretation are in effect when the parties to an investment treaty get together and release a statement, or a binding statement in effect on what they believe the document that they signed is. However, in the absence of express provisions in the treaty about the effect of a note of interpretation. The note of interpretation itself is not necessarily binding, but only sort of indicative or suggestive of the party's intent or understanding at the time of the conclusion of the treaty. And here we have a quote from the Court of Appeal of Singapore in reviewing the Sanam versus Laos award, wherein China and Laos had issued a note of interpretation about the sort of jurisdictional extent of the treaty. And because that note was issued after the dispute arose, there was questions about whether or not it really reflected the intent prior to the dispute, or it was just a matter of two states sort of having a preference for how the dispute would come out. And finally, after a treaty is set to expire, that is another sort of effective moment for a state to jump in and sort of adjust or advocate for change in its investment treaty practice. So investment treaties typically have a duration and termination clause, but provide that unless expressly terminated in accordance with that, the treaty would renew automatically. So in lieu of letting that renewal date lapse, an investment treaty that is no longer in Armenia's interests, Armenia would be able to step in at that point and say, we are looking to terminate the treaty, and but are open to negotiating a new one. As an example, here I reviewed two examples of the Netherlands-Indonesia BITs. There's actually been sort of three sets of negotiations in the history of this bilateral investment relationship. The original 1968 treaty provided for exit arbitration for any dispute arising with that investment. That treaty was eventually terminated by Indonesia, and Indonesia promptly negotiated a new treaty with the Netherlands, whereby the investor was not limited to taking the dispute to arbitration, but also made it clear that the investor had the option, without waiving their right to arbitration, of submitting the dispute to national courts in Indonesia. That sort of reflected a growing policy shift in Indonesia towards the development of its judiciary and promotion of trust therein. The 1994 Netherlands-Indonesia BIT has also since been terminated, and Indonesia is the reason for that is because the Netherlands BIT specifically have often been used by sort of entities that don't really have an effective business presence in the Netherlands, but sort of essentially a shell or a holding company there as a basis to make themselves to avail themselves of the wide network of BITs Netherlands has concluded. But Indonesia has made statements that it is open to negotiating a new treaty through the ASEAN framework for sort of investments made by Netherlands Dutch companies with a presence there. So that concludes my That concludes my review of sort of the analysis of what the investment policy for Armenia can look like, and the tools available for Armenia to tweak and improve its position more in line with its expectations.
Thank you very much, Levon. It was very useful, and also I really like the history of interpretation of Indonesian Netherlands BITs. That was amazing. And now, I guess we are a little bit over our time, but we will open the floor to the questions. So we have received several questions through email, so I will just open out loud those because those don't have a specific addressee. So just feel free to pick those up in case you want to. So the first question, I will read it out. Considering the Argentinian case where the right to water was considered as an essential human right, if we were to apply the tribunal's analysis to the mining dispute where contamination of drinking water resources is concerned, how likely it is that the tribunal will find a violation and rule against the investor? So I guess the question, the person who was asking the question was referring to a famous case where the right to water was considered as superior to investor protection. So please, anyone wants to answer the question? Great, Julian.
Yeah, so can you hear me? Okay. Yes, so this is a very interesting question, which alludes to the Ubasa versus Argentina case. The problem is that it is almost impossible to make general assumptions about how the right to water can come into play. And this is, of course, caused by several points. So the first one is that we have a system of ad hoc arbitration. So there is no precedent and no tribunal in any future dispute will find itself bound by the findings of the Ubasa tribunal. So this is the first aspect, which limits the importance and the consequences of this kind of decision dramatically. The second one is that most of the time tribunals have shown a very pragmatic approach when it comes to disputes, for example, in the water treatment sector. So they will ask themselves whether the state acted reasonably, or they will look into the applicable concession contracts instead of going into the wild world of international human rights law, and especially in fields which are disputed, such as the scope of the human right to water. So a tribunal will most of the time try to avoid that. And if the tribunal, however, concludes that there is a problem in the water management, and this is a fact-based finding, so we have reliable expert opinions, for example, or we have clear provisions in the concession agreement, then it is very possible that the tribunal is very happy to take these considerations into account. And in this context, it might also refer to the human right to water, but usually more as a supplementary or secondary line of argument.
Thank you, Julian. Our next question is related to the legality of investment, I guess. It will be addressed to Camila. So can a host country cancel a mining project with an international mining company without consequences if mining technical documents presented at the time of permitting and contract signing are incomplete, which makes the host country unaware of the environmental risks involved about the project?
Thank you, Aram. So I was thinking about this question, and thanks for sending it in writing. It's very much based on the facts, first of all, because it's very easy to sort of summarize complex matters to a question. But the way I read this question is that a country decides to cancel a mining project, but it seems that someone had signed the permit despite some documents were missing. So here we have two issues. On the one hand, it seems like that the investor didn't comply with domestic law because failed to provide all the required documentations. But from the questions that we have received, it seems that the government has signed nonetheless. Right. So obviously these create a bit of an issue, right? Because again, I don't want to give a legal advice, first of all, and it's just an hypothetical, but according to what I see, if the situation is, okay, the foreign investor failed to give important documents that were required under the law, and the BIT provides for a provision as the one that Levon was commenting before, the requirement of having an investment done in compliance with domestic law, well, definitely, I think that the state has strong grounds to, in a way, knock out the claim on the basis of the legality of the investment. And as I was saying before, there are some tribunals which would recognize the requirement of legality despite the absence of such a provision in a BIT, okay? So that's one side. On the other hand, if at the same time the state has nonetheless signed the documents, I think that here we have an issue of estoppel in a way, right? Because there has been a sort of a ratification in a way of what the documents that the investor gave to the officials. And so I can see how an investor can raise any sort of legitimate expectation argument, because the investor can say, okay, you say that I failed to provide some documents, but you as official authority ratified them. So I must say, I mean, and apologies if the answer is not satisfactory, but it's very, very difficult to say whether the host state will be right or wrong, because it really very much depends on the facts of the case. Certainly, if a state decides to revoke a permit, I think that we have to go back to what we were discussing before. What Julian very well explained in the concept of human rights applies also here. I mean, we have to look at the proportionality aspect, whether the measure was legitimate. And in this case, I would also think of due process, good faith, and so on. So there is not a yes or no, or you're right or wrong answer here. These cases, as the dispute involving Armenia, are, I'm sure, very, very complex, and there must be tons of documents to read. So, but this is what I can say on the basis of the question that I have received.
Thank you very much. Thank you. Okay, so our next question will be to Levon Gevorkian. His presentation was on how we can improve the bilateral investment treaties with Armenia. And the question is, how can Armenia improve its bargaining power in negotiating or renegotiating investment treaties? Could you please, Levon, delve into that? Thank you.
Bargaining power is often a function of, in its rawest form, it's a function of economic size and legal specialty. So Canada, for example, has a strong policy position about how it wants its investment law to look. So even though as an economy it's not huge, it is still bigger than Armenia, but in practice, if you look at Canada's investment treaties, they almost always mirror exactly what Canada's model BIT looks like, because Canada has a strong position about what, if it's going to engage in investment treaty negotiation, this is how it's going to look. So sort of hard-headedness is one example of improving bargaining power. But I think for a smaller state like Armenia that doesn't have raw sort of GDP size, the Indonesian experience might actually be instructive, because bargaining power for Indonesia came in spikes as investment flows were shifting. So at a time that Indonesia liberalized its economy to attract a lot of foreign investment, there was it created a contemporaneous demand for investment into Indonesia, and that demand is small by comparison to many other states at that time, just because the Indonesian economy was not yet a high value economy. But the fact that there was a lot of demand for that flow into the state at the same time created a improved Indonesia's ability to renegotiate at specific periods in time. So I think a policy shift or a declaration of a specific policy, whether it's sector specific or general with respect to foreign investment, is one way to drum up experience. Another is sort of still doing the model bit, because even if you are compromising on certain aspects, at least you have a baseline for negotiation. And Armenia is particularly interesting because it has had relatively more success in negotiating investment treaties with the Middle East without being sort of an Arab state itself. And investment treaties in the Middle East are still fairly there's not much standardization yet. There's not much there's fewer model bit practices there. So relatively speaking, even if Armenia's economy is not larger, the fact that Armenia has experience with these treaties, it can distill that into a document that can form the basis for negotiation with, plus or minus certain terms.
Thank you, Levon. And as just to sum up your answer, do you think creating a model Armenian BIT would put us on an equal, or maybe not equal, but in a better foot with other countries with whom we are going to negotiate the BITs in future?
So to summarize, I think it depends on the target jurisdiction, whether they are a sophisticated negotiator with their own model bit, in which case the fact that there's a second model bit on the table is less influential. But if you're, again, for example, if you're targeting the Middle East, I think it would be relatively more effective and can't hurt either way.
Thank you very much, Levon. Since we are over the time of our webinar, I will close the floor for questions. I would like to thank again our speakers for finding the time and sharing their expertise and knowledge with us. I hope the webinar helped us to bridge the gap between the environmental law, human rights law, and the investment law. And I hope to see everyone during our next webinars. Thank you, everyone who has participated, and see you in our next webinar series. Bye-bye.
Thank you.